So in chapter 14, we looked at capacity and legality when it comes to contracts. So for the first section, it was uh, minors and the disaffirmance of contracts. So basically, a minor can uh, agree to any contract that an adult can agree to, except for those that are prohibited by law for minors. Um, Now, with that, minors are able to disaffirm a contract whenever they want. There are some exceptions to this, however. Some of the main exceptions are that they have to express that they want to get out of that contract, whether that be through words or through conduct or whatnot, but they have to actually make sure that it's known to the other party that they want to get out of that contract. Um, Another thing is that they have to disaffirm the entire contract. Uh, you can't just disaffirm part of a contract, it has to be the entire thing. So, say, like, you're a minor and you get into a contract and you like one section of it and you absolutely hate the other one, and you only realize that after the fact. And the thing is, you have to decide whether you like this one enough to keep it or you dislike this one enough to get rid of the entire thing, because it's one or the other. You can't just get rid of this part, you have to get rid of the entire thing. So that's another thing that minors must consider. In some states, they do require the minors to return the items within the contract, whatever that may be, back to the original condition. Not all states do this, but there are some states, and so that can sort of be a tricky problem sometimes, because I know in class we talked about a used car or something like that. So say a minor gets into a contract with a car for a car, and I mean, you drive around the car, it's going to put on mileage. So how are you able to get that to a point where it's in its original condition? That's a hard thing to do. But for other things, it's a little easier. But that's the main thing. You have to return it in the original condition. Um, in most states, if a minor lies about their age and they get into a contract, um, it's not a big deal. They can still disaffirm the contract whenever they want. Um, However, there are some states that are putting laws in to prohibit minors from doing this. So if they lie about their age, this can prohibit them from trying to disaffirm a contract or get out of it. So a minor can disaffirm a contract at any time, uh, whenever they want. However, once they reach the age of majority, they must, or emancipation or whatever, they must uh, disaffirm that contract within a reasonable time. If they don't do it within a reasonable time after their emancipation, um, that can create some problems, because you can't, once 2 years after you reach emancipation, be like, yeah, I don't want to be in this contract anymore. Like, that's too long of a time. So if that's the case, courts will decide whether it's uh, um, disaffirming the contract, or if it's ratification. And the ratification can be two ways. It can be expressed or it can be implied. So implied is when the minor, when they reach the age of majority, indicates that they intend to abide by the contract. So whether that be through, they continue using the vehicle or something like that, like their actions show intent to abide by that contract. Expressive means that once they reach the age of majority, they actually state uh, um, orally or through like writing that they will uh, be bound to that contract. So there's two ways, and so if it's not a reasonable time after, the court will decide whether it's that or not. Um, how does the court view capacity intoxication and mental incompetence? So when it comes down to the validity of a contract, intoxication can be a problem sometimes. So obviously, everyone knows what it's like to. Everyone knows what being intoxicated is. So a contract can be voidable if even with voluntary intoxication. So obviously, if it's involuntary intoxication, the contract is going to be voidable because they were not trying to become intoxicated, and that can affect their decisions when it comes to making a contract. So obviously, that's going to be like that. However, if it's voluntary intoxication, it can still even be voidable because if they were intoxicated enough that they lacked like the mental capacity to make rational decisions when it comes to agreeing to that contract, that's when it can become voidable. The contract can be enforceable if the person did actually understand the consequences of the agreement despite the intoxication. So there comes to a point where they have to be able to decide whether or not they were lacking that mental capacity, whether they were too drunk or whatever, or if they were a little bit intoxicated but they could still understand what was going on. So a court will actually look at the indications of the intoxicated person. So, for example, to determine whether or not they lacked or required the capacity, one way they could do it would be through the terms of what the contract is. So, if the contract is completely unreasonable, then and it's something that no one would do in this sort of industry or business, then it can be determined to be voidable. So that's just like one example of how a court would look at that. So the next thing is mental incompetence. So basically, a contract can be voidable if a person does not have the mental capacity to make that decision. Basically, if the person is determined to be unable to make those decisions, they're mentally incompetent, that contract will be void. There is cases where the court will appoint a guardian who will represent the mentally incompetent person and enter into binding legal obligations on their behalf. The contract can be voidable if the person did not know he was entering the contract. So again, in class we talked about people with Alzheimer's when they forget sometimes, and so sometimes they don't realize what they're doing. They forget things. They enter a contract while they're in a certain phase that they're going through. That's something when it can be avoidable, or they lacked, they weren't able to understand its nature, the purpose of it, or the consequence of what the contract is all about. So those are basically different ways that it can be voidable. It can be valid if a contract is entered by a person who is mentally ill but not previously declared incompetent. So there is a difference between the two. They must be able to, have the capacity at the time the contract was formed. So basically like that. basically they're able to understand what was going on. So the next part is wow, I'm 10 minutes. Holy crap. I apologize. It's so easy to talk about the whatever. What are unconscionable contracts and how did the court view these? I'll try and fly through these. Okay. Unconscionable contracts. Contracts whose bargains are so oppressive the courts will relieve innocent parties of all of their duties. So if the contract is sort of like way one-sided, it doesn't make sense. Like, why would the person get into this contract when there's nothing for them in it? They get nothing in return, sort of thing. When it's something crazy like that, then the courts will relieve them of their duties. So that's an unconscionable contract. There's procedural unconscionability. Basically, this is often involving inconspicuous print, lack of an opportunity to properly read the contract or the questions behind it, and they weren't able to ask questions, or it was written in a way where people weren't able to understand it. Basically, the contract was sort of made against the weaker party, and the consent isn't always voluntary because they don't know what they're getting into, or it wasn't voluntary at all. Then there is substantive unconscionability occurs when contracts or portions of contracts are oppressive or overly harsh. They will sort of tend to courts will focus on provisions that deprive one party of benefits under agreement or leave that party without a remedy or for non-performance by the other. So the next thing is exculpatory clauses. Basically, this is releasing a party from liability in the event of a monetary or physical injury, no matter who is at fault. So basically, this is enforceable for a number of different reasons. They're not always enforceable, but basically they are enforceable for when they are not against public policy, they are not ambiguous, and do not shield parties from intentional conduct. All of the reasons, they would be not enforceable. So that's basically what an exculpatory clause is. Sorry, I tried to fly through those last couple things because I took so long doing the other ones. But yeah, like I said, no matter who's at fault, you're going to release the party in the event of an injury, monetary or physical injury. So that was chapter 14.